start. Good evening, everyone. I'm the Commission of Practice in Italy. We are recording, so I have to speak here. I'm very happy and glad to introduce my colleagues today. Christopher Graff, a partner from Competition and Antitrust Department based in London. Hi, Chris. And Maria Brakalova, a partner from our Competition Antitrust practice in Berlin. Why we decide to focus this afternoon on FDI? Because as you are aware, FDI, I mean foreign direct investment screening, has growing in importance across the world. We are focusing today on some topics in the European Union level, but having also the global perspective. Why it is interesting? Because the current geopolitical tensions across the globe are increasing in the relevance, and it is now key to know since the very beginning of the negotiation on any relevant M&A transaction which affect potential relevant assets and goods in Europe and in the world, to have in mind what will be the impact from the foreign direct investment screening. We will share our experiences today with you. We will share with you some figures, and I think the most important part is to share some practical insights, some experience that we have assisting our clients and our clients and our colleagues, internal colleagues, when they design a complex M&A transaction. I will give the floor to Maria for a brief overview of FDI review powers in Europe and worldwide. Please, Maria.
Yeah, thank you very much, and good afternoon also from my side. Thank you for this kind introduction. I'm happy to participate and discuss today here with you and my colleagues on foreign direct investment screening topics. For those of you who may be not so familiar with this, I guess most of you are, what is this about, the FDI review powers? Here we have a short overview about how this functions. So basically, in most of the jurisdictions, these review regimes, address some potential threats to national security or public order, public health. In some jurisdictions, it's even a broader concept of national interests. And also what we have seen during the past years, that especially the pandemic, but also other factors, have accelerated these review regimes or control regimes and their development in many jurisdictions. In most of them, the concept is a pre-notification procedure for some mandatory notification cases, together with a standstill obligation, and there are also some post-closing challenges or risks, even in cases where there is no mandatory notification. Within the European Union, one may think that it's a quite harmonized or unified regime, but as we discussed before we started, and also with many other colleagues and clients, it's not. That's a pain, so there is no harmonized FDI screening procedure. We will come back on some EU regulations on this, but this is not a one-size-fits-all matter, so we have to take a closer look in different jurisdictions, even within the EU, when it comes to FDI topics. And what is made also very important to know, usually there are specific timelines for these review proceedings. In most of jurisdictions, there is a phase 1 and then the phase 2 timeline or deadline. We will also come back to this a little bit later. But it's a set timeline with some judicial control, but with a very broad political discretion in many cases. So this makes the whole review procedure a little bit unpredictable from time to time. And the sanctions, there are sanctions in many jurisdictions if you don't notify, if it's a mandatory notification case. And there is also a risk of, in a worst case scenario, of course, of unwinding the transaction even post-closing. This is also a risk. In some jurisdictions, there are now also some criminal penalties for intentional, for example, exercising of voting rights by the foreign investor before clearance has been obtained in a mandatory notification scenario. So this is just for the overview. Now I will pass over to my colleague on the right, to Christopher, for the next steps.
Thanks, Maria. And buonasera, everyone. I think one theme that will come through what we talk about this afternoon is it's become a very complex landscape, and it's become very complex very quickly. And so we start thinking about that. What are the drivers or factors underlining that? One factor is that we've seen the notification thresholds lower in a lot of countries. And that happened in several countries during the pandemic, where the market suddenly crashed. They were concerned in very depressed economies about assets being bought at rock bottom prices. But a lot of the lowered temporary reductions have actually taken a long time to come back up. Equally though, a lot of reforms to existing regimes, new regimes coming in, are going for quite a low notification threshold. So you don't have to have a very significant local nexus or turnover or asset values in that country before you're potentially caught by its FDI net. And so just an example I was looking at just last week, the new Romanian regime, it's very new. I mean, that basically puts a 2 million euro local asset value turnover test as to whether the regime is triggered, among other things. So you can see it's quite a low threshold in a large international transaction. The second point, and we'll come to this in further detail, is we've really seen FDI regimes mushroom out from the traditional areas of perhaps defense, critical suppliers to government, to a much, much wider range of sectors: telecommunications, healthcare, energy, other infrastructure that you really might query whether it is truly critical to national security. But nevertheless, we are seeing a significant widening of sectoral scope. So we just, a lot more deals in different sectors now have to be looked at for FDI. The other reason why it's complex and important to navigate right is because it's a mandatory standstill obligation. You can't close your deal until you've got the clearance in most cases. Not all, but most. And lastly, again, it comes back to this point Maria was touching on. It's complex and it's important to get it right because the risks are significant. They're fairly similar in some ways to merger control. You've got forced divestments or unwindings. You've got the effect of the transaction being null and void. And in some cases, we are seeing quite significant abilities to look back at past transactions, and also with some new regimes. When the new UK regime came in at the start of this year, and it's proposed the same for Ireland's new regime, which should come in perhaps early next year, that gives the governments in those countries the ability to look back at transactions that closed before the regimes even came into effect. So it's a rare example of retrospective application of law. Next one, thank you. So another reason why it's become so complex is the coverage. I think around this table we can all agree that 3 or 4 years ago we looked at a transaction, we had a short list of jurisdictions that we thought had to be sort of up the list to see if the transaction might trigger FDI controls in those countries. As you can see from the map, actually FDI controls now span the majority of the developed economies in the world. And again, it's been a rapid expansion globally, and as I'm going to I think Maria's going to touch on in a moment, particularly within Europe.
Yeah, thank you. So here you can see a map taken from the very fresh second annual report from the European Commission that was published on the 1st of September, so really fresh. And here the Commission provided the information or the overview that now we have 25 out of 27 EU member states with some type of foreign direct investment screening procedures or mechanisms. So in some of these countries, this is a quite well-established procedure now, like in Germany, Italy, France. In some other EU member states, these regimes are quite new. Some of them were initiated and implemented during the pandemic, and some are now in the course of legislative process expected to come in force within this year or next year, like, for example, Belgium or Ireland, the Netherlands with a new, more comprehensive FDI regime. So they are only the last two Mohicans, Bulgaria, Cyprus, without any type of FDI screening regime so far, but the pressure from the EU Commission, I have the feeling, is quite big here. Of course, best practices, workshops, discussions with EU member states are also accelerating a little bit this process. So I think maybe next year or in 2 or 3 years, all of them will have some sort of FDI screening regime. And for the UK, Chris already said something about it, but maybe you want to add something.
Yeah, I think, unfortunately, as a consequence of Brexit, we now have to talk about the EU and then the UK. So I think what's quite striking is in the UK, which was traditionally seen as a very open to trade, deliberalised economy, the new regime that kicked in January of this year is a very all-encompassing, intrusive, far-reaching regime. And I think, it sort of goes to the point that, yes, there are a variety of regimes and each is different, but we are seeing countries bringing in new regimes that are not just sort of light touch, oh, the Commission have kind of pushed me to have something, so I'll have something. There are some of those around, but there are a lot of regimes, the UK being a good example, that are significantly more complex and burdensome than that. For example, it catches UK investors making investments in UK companies. It catches internal reorganizations in some cases. It really is it catches licensing arrangements, not just actual M&A activity. So I think for the more complex regimes, as we've got to grips with it over the past 8-9 months, it really is a case of being able to get to grips with all the ins and outs as to what actually is caught, what sort of transactions, what sort of investors, and so on.
Yes, thank you. And this also leads me to one side remark. So we always talk about foreign direct investment, FDI. This is like a term that has been developed during the past years, but actually we have to be careful with this term because it's not always foreign. As Chris just said, in some jurisdictions, even domestic investors may trigger such a screening regime in critical infrastructure, also sensitive technologies. And in Germany, for example, it's not only about foreign direct investments, it's also indirect. So we could also say foreign investment or just investment.
Just foreign.
Okay, so here you can see some nice colored sectors that are typically caught by mandatory notification procedures. For example, some sensitive technologies like artificial intelligence, robotics, autonomous driving, these type of things. So apart from the critical infrastructures in the energy or telecommunication and so on sectors, we now have in many jurisdictions sensitive technologies as well. Maybe you want also to add something?
Yeah, sure, absolutely. I mean, I think, again, in some ways, this pictorial illustrates the complexity and extent of these regimes, but the challenge actually is you've got something like robotics or artificial intelligence. Not everything in a given country to do with artificial intelligence is caught, and it's about working out where the bright line exists. I think the other interesting point you see, and this is certainly coming through in the UK, Despite there being a wide number of sectors potentially caught in our new UK regime, we have 17 sectors that are subject to the regime. But actually, in the report produced by the UK government on the first 6 months of the regime, the half-yearly report, of all the notifications made, defence and dual-use notifications comprised more than 50% of the notifications received. So that's 2 sectors out of 17 comprising more than 70% of notifications. And if you add critical suppliers to government into that, so you've got 3 out of the 17 sectors, that accounted for more than 70% of all the notifications received. Now that will differ by country, but I think what that goes to is, yes, there's a broad range of sectors. The traditional core ones of defence, dual use, critical inputs to government are still very much front and centre of almost all regimes. And actually, as a practitioner advising on a transaction, the tricky thing is to work out in those perhaps more novel, modern, technologically based sectors, what is in and what is out. Because either you're too bullish, you get it wrong, and the transaction should have been notified, it isn't, or you end up making overly conservative and cautious notifications, which doesn't really, benefit the parties in the transaction. So I think that's a real challenge for lawyers in this sector, is to be able to work with clients collaboratively to understand what's in and what's out.
We will come to our strategies a little bit later. But
Giving all the
thank you.
secrets away.
Yeah, but also, another important remark is that even if the transaction and the asset is within the scope of the law, this does not necessarily mean that the transaction will be subject to any remedy or to any veto, because if you see the number, and we will discuss this in detail later, at the end of the day, it's increasing the number of notification made on a sort of cautious approach, or a prudent approach, as we say in Italy, but at the end of the day, the veto decisions are still rare. They are there, but are still rare. I think this is important to know. And I think this is confirmed by the figures. We collected some data, mostly to show you, and I'm really much impressed by the green line. This is the share of global FDI potentially subject to screening under sector or specific legislation in OECD countries. And you can see how this line goes up and up and up. Obviously, the recent trends confirm, and the geopolitical tensions confirm that something is changing. So if you see, for instance, the recent veto decision by the Italian government, and they are just 6, you will find that 5 of them are related to a Chinese investor, and 1 of them a Russian investor after the Ukrainian crisis. So again, here we are talking about a matter which is very delicate, but the burden between the political assessment and the legal assessment is very, very teeny, is very, very strict. So when you design your strategy, you should always bear in mind also the context where the transaction is taking place. So we are not discussing in detail this number. We will give available these slides to all of you. But I think another important data is this: the number of jurisdictions which have designed and implemented or even reinforced the foreign direct investment screening within the OECD has increased in the last year. So this is something which is not temporary. This is something that will stay here for the next decades. It's something that is changing profoundly the relation between the openness of the market and the relations that you should have with your local authorities when you deal with a transaction which is related to a potential critical sector or assets. Let's move a little bit on what is happening in the European Union. As you know, we have implemented a new cooperation mechanism. This is that has been designed having in mind what happens with the merger control law. So the idea, but it's not still there, maybe we will reach this in the coming years, to have a sort of one-stop shop. At the moment, we have something less ambitious. We have a cooperation mechanism where the European Commission collect from each member state, and again, the nature of the assessment is still related, as has been remarked by my colleagues, on the national security, on the public order, and these are intrinsical national assessments. But in any case, I mean, the start of the process is at the local level in the 27 member states, and then there is a cooperation mechanism which is referred to the European Commission, which has the power, and Maria will go a little bit in detail on this, to make observations or comments regarding the transaction that has been notified in each member state. This is critical, especially because you should be aware when you notify a transaction in one of the 27 member states that sooner or later the other member state will be notified. So be careful to make a proper assessment to cover all the jurisdictions. And secondly, we have already cases where the transaction was notified prudentially in one member state, and the European Commission referred this to the cooperation mechanism, and the other member states said, look, I want to have a closer look here. They didn't notify in my jurisdiction, but this is relevant to my interest and my national interest. So they open a specific investigation based on the lack of notification in the member state where the assets were critical, but based on the cooperation mechanism. There are very interesting numbers. As a last remark from my side on this slide, in Italy, on Monday, we'll enter to the second reform of the Golden Power rules. We are introducing the pre-notification system. The aim of this reform is to make a little bit easy and friendly the relationship with the business community. Why? Because we registered, and the numbers for Italy confirm, we registered an increasing number of notification. We started from 46 in 2018. We reached 342 in 2020. Why? Because the majority of these transactions were notified only on a prudential basis. So the idea for the pre-notification is to smooth a little bit this process, to have the possibility to contact the authority, in this case the Italian government, and to confront in an open way if the transaction is subject to notification or not. We will see if this process will have beneficial effects in practice. As I said, it will enter into force on Sunday, but I mean, this is another very, very important topics to closely monitor, and maybe it could be a best practice in the European environment. Maria, go ahead.
Yeah, thank you. I don't have to add too much on this slide because you already explained this cooperation mechanism EU-wide very well. This, of course, is a challenge not only for our clients, but also for us to coordinate even much better than we did before, because we are aware that national authorities communicate within this cooperation mechanism much better than they did before. So the filings have to be consistent. We have to describe the transaction in a consistent way. Would be a little bit difficult to explain why there are inconsistencies. So we coordinate in these multi-jurisdictional projects when there are several EU member states involved much more intensively than we did before. In Germany, there are also, the numbers are also increasing, so we also have numbers for 2021, not on the slide, but I can tell you that there were 306 notifications in Germany in 21, and these are purely the German notifications. On top of this, Germany, of course, received from many other EU member states through this cooperation mechanism, I think round about 400 additional cases, and these are two departments dealing with the investment review procedures at the German Federal Ministry of Economic Affairs. I think round about 14 people, so you can imagine that they are very busy. And from the second annual report from the EU Commission that I mentioned before. There is some even more fresh data. So we now know that within 2021, there have been 414 notifications submitted through this cooperation mechanism in the EU. And the Commission proudly states, or notes in this report that most of them, I think around about 85, 86% were closed already in the so-called phase 1 review procedure by the Commission. So the positive message here, our cooperation mechanism is not a burden. We may see this a little bit different because it's a black box a little bit for us. We don't have the direct contact with the EU Commission. We have the direct contact with our national authorities, but all this communication is through the national authority when it comes to the EU Commission is asking questions or wants to know something in more detail. So we cannot really directly communicate. This makes it a little bit intransparent for us and for the clients. Yeah, but the positive message here was that it's not a very, so to say, timely consuming procedure that comes on top of the national timelines. But we have to review this. It's quite a new mechanism at the EU level.
Thanks, Maria. So, as you can see, the landscape's quite complex, and it's not getting any easier.
Reassure the participants to this seminar that it's true that there is some political consideration regarding the assessment of the transaction, but at the end of the day, the regulation is very clear that some principles should be respected in any review process locally. I'm talking about European Union, of course. First of all, the due process. I mean, the party should have the possibility to access to the file. They have the possibility to make a constructive dialogue with the authority. They should even appeal the final decision, and now we are registering, especially in Italy, but also in other jurisdictions, some appeals brought by the party who suffered the veto or suffered burdensome conditions in order to ask to a judge to review the proportionality and the necessity of the veto or the remedies. And this is very important because these are the this is the legal framework within the assessment of any transaction should be made. So don't be scared about the political element. Obviously, it's a part of the game the party should be aware of, and I fully agree with Chris, and actually we advise our client always to have someone in the public relations, in the institutional relations, in the team, but at the end of the day, in Europe, I'm not talking about the US or China, which obviously they have a different approach, but in Europe, this is still a review based on the law. And so the rule of law should be respected. And as a part of this, it is the timing. You know that the timing is key when you deal with M&As. I mean, time is key not only in the design of the transaction, but also in the implementation of the transaction. And both Maria and Chris recalled us that there is a standstill obligation. Standstill obligation means that the seller cannot bring the money until the last government says, okay, this is fine. And if you see the timeline, and again, the procedures are based on the national laws, you see, for instance, that in Spain, the regular period of time that the government takes, the Ministry of Economics takes to make a final decision is 6 months. I mean, the timing is disruptive if you think how tight is the timeline under a merger control phase 2 review. And also we know how rare are the phase 2 reviews, and it has been just recalled in the previous session, under antitrust law. So again, timing is key, and the respect of timing is key. So our experience is that the government sometimes try to get some additional time, stopping the clock, or reset the clock sometimes when they think that, they need more information or the filing is not complete. Sometimes this is used instrumentally. You know, we have experience in some applications lodged on August, and it's typical period when, it's a summer break or almost in Europe, and you receive the typical request of information just to stop the clock and take more. So this is something that should be obviously taken into account. And also our experience tells us that every month that passes, the financial risk connected to the transaction increases, the financial cost increases, not only for the team, for the legal team, for the legal cost, but also, for instance, imagine the cost of the financing of the transaction. So every day counts, and for this reason, we think that a successful strategy, especially when more than 2 jurisdictions are involved, especially when you are dealing with jurisdiction outside Europe, starts from a clear design of the transaction since the very beginning. One best practice could be, in our experience, to be ready at the signing with all the filings form already approved and ready. Okay, because in this way, you can ensure that when the party sign, you are ready to lodge immediately the text, which has been already approved by all the parties in all the relevant jurisdictions. And this helps, obviously, in speed up the review process. But again, Maria and Chris, please feel free to add other pieces of your experience.
Yeah, thank you. Maybe just one additional aspect on stopping the clock. Resetting, for example, this was the case in the previous FDI screening mechanism in Germany, and also for gaining time, all these things has been also an issue there, but stopping the clock is still an issue, better than resetting, but still, if you are, for example, in the German timelines, they are quite long. So you have 2 months for phase 1 and 4 months for phase 2 with extension possibilities up to another 3 and 4 months and whatever. And then you have sometimes very sensitive cases where you have to negotiate something with the government. So, for example, negotiate a contract with them. And during this period of negotiations, the time also stops. So this is also something that has to be kept in mind, especially, for example, in Germany. It's the authority who wants to make the first draft of the contract, so they don't allow us to make the draft. So we have to wait for the draft and then comment on the draft. And this can take, of course, a couple of, let's say, positive weeks, not so positive months. So this is something that really has to be considered. But fortunately, negotiations are not, I mean, the majority of the cases. So this is only for really very critical transactions. Yeah, and for the next one, in terms of strategy, how to manage risks, uncertainties, this was already said here that there are some formal or informal possibilities of engagement with the national regulators. Yeah, fortunately, we have good contacts. Of course, if you deal with these type of FDI clearances on a regular basis for years, you know the people in the ministries, they are growing and changing, of course, because they need more people. But still, you have some key contact persons. This helps just to have, for example, sometimes a call and discuss something, an aspect on the scope of the whole business, target business, because sometimes it's not 100% clear, maybe in mandatory, maybe not a mandatory notification case. Then there is something else to be considered in cases where it is not mandatory, but you have some concerns that maybe because of the investor's background, for example, is a state-owned investor coming from certain jurisdictions, or the thresholds, the relevant thresholds, for example, for critical infrastructure are not met in this transaction, but nearly met. So things like this may actually lead to our advice for a volunteer notification. But then again, with the voluntary filings, this is not, I think, typical in all jurisdictions. In Germany, we use this instrument quite often, but still we have to consider together with the client then both sides of the medal. So positive aspect is legal certainty, of course, because if you have this voluntary filing, you get an answer at some point, and then you have legal certainty. You don't have to have sleepless nights for 5 years after signing. Okay, but then you have the other side of the medal, that this may trigger attention in cases where maybe this attention is not so advisable. So because of this notification procedure within the European Union, even voluntary filings may trigger this information exchange. So these are strategic aspects to be considered in our or your transactions. And yeah, I pass over to you, Michele.
I will take advantage of these few minutes. I mean, we are technically, advantage of opening the floor to some questions, because this has been already covered more or less.
I think that's right, yeah.
So, okay. So is there any question or any experience you want to share with us, having in mind also the consequences and how important it is to anticipate the assessment of the FDI since the very beginning of the negotiation? Marcello?
Thank Thank you. I'm in-house counsel at Clariant. My question is, when would you start engaging with the authorities on a sort of informal contact in order to see whether a transaction may trigger or may raise concern and so on? Are we in a merger control where we need to have at least an agreement, or we don't go before signing, or can we do this right before, much more before, to gain clarity before the signing? Thank you.
Yeah, maybe from the German perspective, for example, it's also possible what we sometimes do, even on a no-name basis, to engage with a ministry to clarify something about the scope, for example. But if you really want to start with a voluntary filing, for example, then at least you should have the term sheet in place, so the main structure of the transaction, the parties and everything in place, and then you can do even much earlier before signing this notification. You can also notify in mandatory cases before signing. This is also possible. Because in Germany it says you have to do this immediately after signing, but immediately is also not defined. I mean, could be 1 day, could be 10 days, depending on how complex this is. But you can do this even before, and then after signing, you just notify that signing has taken place. So this is also possible.
Mm-hmm. Chris, do you have something?
I was just going to say, it's an annoying answer, but it does depend on the country. So when we coordinate sort of global projects, for example, in France, if there's uncertainty, the MINEFI, the relevant ministry, will almost never engage with you to give you informal guidance as to whether you're in or outside of their regime, and you have to basically put in a filing or self-assess. The UK is probably closer to that as well. Some limited opportunity for guidance, but otherwise you're sort of into, do I put in a voluntary filing or a mandatory one? So I think that is the challenging bit. It's about early enough working on where your sort of grey jurisdictions and actually figuring out what your strategy is for each of those as soon as you can, really.
Yeah, fully agree. I mean, one piece of experience from Italy, we will test the new pre-notification system starting from Monday. And now it's interesting because the law clearly says that you can communicate a project of transaction, so something which is not final, of course. And they say, look, you can come to us in written. So again, this is not just a call or an email. I mean, you should send something to them. The forms have not disclosed yet, but I guess that you can use the traditional form, filling it with the information that you have at that time, okay? So, and they say, obviously, as complete as possible. I mean, if you have already some documents, if you already the business plan, if you have already other important information, please send us. And so this was completely inconceivable in the previous regime, because the law, before the amendment, said, no, you should come here after signing, and not immediately. They said 10 days after signing, no 1 day later, no before. And every time the parties, in this excess of prudence, tried to notify something which was not binding, the government said, no, this is no binding, so please come to us back when you have signed the contract. So the preliminary contract, for instance, was deemed to lead a sort of incomplete notification, incomplete filing, and so tam quam non esset, so it doesn't exist. And so any clock started ever. So very good question, Marcello. We will see, and I think there is a lot of expectation in Italy, especially in order to see what is the minimum requirement that allows to be qualified for a pre-notification. If you can let me add a few comments on this. After the pre-notification, the government can take up to 30 days to say yes, no, out of scope, or yes, come, notify, because this is subject to some remedy. But 30 days is, it's not that different from 45 days. And, you know, so strategically again, especially because in our experience, it's very difficult that the parties have something formed, some document formed 30 days or even earlier from the signing. So maybe, again, it should be tested, the effectiveness of this system. Obviously, if the government will reply immediately, in 5 days, 10 days, say, look, okay, this is clearly out of scope, no problem. But if they are taking all the whole 30 days, the risk is that they say, come and notify, and then after that 30 days, you should add the 45 working days. So you are, you know, under a big risk of delay. So it's something that we should consider. Any other comment or questions? Any final remarks from your side? There is a very interesting walking tour in the Fori Romani, so we don't want you to lose the bus. But I mean, I don't know, Maria, maybe you can make a final remark on behalf of all of us.
Yeah, final remark. So, yeah, I think it's, as we said, very dynamic, very challenging area of law. So also for us, we have to keep on track. For me also, because I also deal with sanctions and export control law, it's also interesting to see these, in some case group similarities. So when it comes to dual use goods, so military and civil applications, they change also depending on technologies, on political developments. So all these correlates also to the FDI screening procedures. So it's interesting. It's of course challenging, but I think at least from what we have experienced so far, is becoming a little bit more a little bit more sophisticated in many jurisdictions, and also the authorities are more willing, maybe in some jurisdictions, to have this dialogue with the business, and at least take the phone or write an email back, because in some jurisdictions, and I know also from China where FDI is quite new in this aspect, national security, it's not so easy to get an answer or to get somebody on the line. So it's becoming better in many jurisdictions. Let's see how this will develop.
So thank you very much, and hope to see you soon in the walking tour. Thank you. Have a good